All right. Good evening, everyone. My name is Holly Vandergriff. I'm with DLS. Chair Charles is running a little late this evening, so we are going to get started and he'll be joining us very shortly. Everybody has the materials. They've been provided to you on the webpage for the task force. And we are just going to roll right in and start with agenda item number 1, opening remarks. But under this, the chair was going to bring up a question that came up last meeting. Delegate Bartlett asked a specific question, and Joe with DLS and Kelly with the MSBA looked into this specific question. Joe, do you want to dive into that, and then Kelly can take over?
Yes, thank you. Good evening. Thank you, Holly. Good evening, members of the task force. Delegate Bartlett, I have it on my screen, asked me a question last week about guarding, a jurisdictional question about guardian of the person. And this is from my handout. So I had the section 13105C1 of the Estates and Trusts article written, which says, with respect to guardian of the person, the orphans court may exercise jurisdiction over guardianship of the person of a minor if the presiding judge of the orphans court is a member of the bar, regardless of whether the minor who is subject to the petition for guardianship of the person has property, may inherit property, or is destitute. So the phrase, if the presiding judge of the orphans court is a member of the bar, I wasn't clear on how this applied to jurisdictions that have orphans court judges who are attorneys and those who do not, and whether this provision would have any effect on how the decision is made on the orphans court. So Kelly did research and she's going to explain all this right now.
Yeah, I wish that there was a clear answer as to what this language actually meant. And it's interesting because Alan Gibber points out that the term presiding judge is not a defined term, and in his excellent treatise sort of lays out a bunch of questions saying jurisdiction is conditioned upon the presiding judge being a member of the bar. Who is the presiding judge? Is it the chief judge? Or may it be any of the judges sitting in the middle of that hearing? Or is it a member of the bar restricted to the Maryland bar? He doesn't answer any of those questions, and I think that's for good reason, because there's not a clear answer. We looked at the legislative history to try and figure out what was intended by the legislature, and none of that provided any clarity. So where we have come down on it, and this is just based on the research, is that we do not believe that the presiding judge alone, even if an attorney can make an independent decision outside of the members of the orphans court panel. It's the orphans court, not a singular judge, that is given the jurisdiction and empowered to adjudicate with respect to the guardianship matters raised in this section. So we think that the panel as a whole must act together, and that the presiding judge's status as a member of the bar is simply a required condition in order for the orphans court to have the ability to exercise jurisdiction under section 13105C1 of the Estates and Trusts article. So we just wanted to provide that additional color to the answer that Joe provided last week.
Oh, thank you very much, Kelly. Does anybody have any comments or questions about this provision? Okay.
Yeah, thank you, Kelly and Joe. If there are no questions, I think, Joe, at this point, we probably want to go to Roman numeral number 2. So number 2, this is not the big topic for this evening. This is just covering a few points that weren't covered at the last meeting because we ran out of time. So we are going to let the registers and MSBA provide their materials and data that was also uploaded again on the webpage for you. It's comparing the jurisdictions of probate courts in other states. And so we're very briefly, just going to touch on this just so that they're able to provide a little bit of background on the materials that they have submitted to the task force. So Byron, Byron and Mary, do you want to start with the register's information?
Yeah, thanks, Holly, and I'll try to be brief and then hand it off to John. I think what I just like to do based on my research is just to sort of summarize that for the states that we have identified that have specialty probate courts, the orphans courts in Maryland really are an outlier in how limited their jurisdiction is. States that have decided to create or maintain a specialty probate court give those courts far broader jurisdiction than we have here. And particularly with regard to fiduciary matters, many of those states give those courts jurisdiction over matters like advance directives, civil actions against fiduciaries, conservatorships, guardianships of adults, powers of attorneys, and trusts. Many also give, and I mentioned sort of in our discussion last week, we were talking about non-fiduciary but probate related matters that come up frequently that require people to take matters into circuit court or district court because the orphans court doesn't have jurisdiction. And those would include things like cemetery associations, certificates of residence, determination of parentage, determining legal title of assets, determining parental rights, elder abuse, enforcement of judgment of claims, grave sites, partitions of property, and paternity. And some of these other courts also have, and I'm not going to read all of these, but some of these courts have jurisdiction over marriage licenses, name changes, divorces, adoption, annulment, alimony, birth certificates, death certificates, involuntary commitment to mental institutions, removal of life support, gender change, and even some jurisdiction over firearms. So again, these other states that have specialty courts have, sometimes extremely broad jurisdiction in contrast to the courts that we have here in Maryland. So I wanted to give that quick summary, and I'm happy to answer any questions, but otherwise happy to hand it over to John.
Not seeing any questions for Byron.
No,
Joey?
Judge Gross has a
Sorry.
question.
I don't have a question, just a comment that the orphans court does have the ability to determine heirs. We have several determination of heirs hearings.
Okay, great.
Thank you, Judge. And it looks like Chair Charles just joined. So I'll let him get situated. John, would you like to go next?
Sure. I don't have much to add. I think we covered most things last week. But I mean, the main upshot of our research, that just adds to what Byron was already talking about, is that there are very, very few jurisdictions, and I can think of only one other or two others, excuse me, South Carolina and I believe Louisiana, that have lay judges hearing any cases relating to estates. So that's the main thing that we haven't covered already in this. Kelly, am I missing anything?
No, I think just to highlight that the research we did on various surrounding jurisdictions seem to align more with what we've been talking about in terms of a unified court to decide issues related to both estates and trusts, guardianships, and fiduciary matters.
All right.
Thank you both. Chair Charles, thank you. We're going to hand it back to you now. I think Senator West has a question.
Okay, real quick. Now, thank you guys for getting the meeting kicked off. I had a groundbreaking. I don't know why they scheduled it so late. We were in the dark trying to take pictures for a groundbreaking of a playground in my district. But thank you guys for getting the meeting jump started. It sounds like you've already jumped into section 2, which is going to be comparing the jurisdictions. Is that
Exactly
correct? All right, and so if you guys are done with that, we'll move to 3. But before then, I see Senator West has his hand raised. So, Chris.
Yeah, thanks. As long as we're on it, before we pass over to something else, do I take it that the experts in this area, the orphans court judges, the state bar representatives who litigate in the orphans courts, think that it would be better to better define the parameters of the jurisdiction of the orphans courts so that there's no confusion? Maybe expand it, but certainly better define it.
I'm not sure. Sorry, I jumped in because I think I'm the only one who litigates these cases on this call. Is there someone else who wants to speak first?
No, go ahead.
All right. I'm not sure better defining the role of the orphans courts can fix the issues that we're raising. They stem from a few different issues. Obviously, there's the lay judge issue, which would be hard to fix.
Right.
The issues associated with the inefficiencies resulting from the fact that the orphans court does have limited jurisdiction. So there needs to be the ability to have things transferred to the orphans court by way of issue transmittal for purposes of jury hearings. The orphans court doesn't have the ability to hold jury trials, and then de novo appeals, which are a matter of right to do it over again in the circuit court. I think in reviewing the various jurisdictions, it seems to at least John and me that there's a tremendous opportunity to take the wonderful aspects of the orphans court and the very well-trained lawyer judges and expand the ability of those judges to handle fiduciary matters, for which they'd be well suited because there is a tremendous amount of overlap between the issues that arise in estates and the issues that arise in trusts and guardianships and other fiduciary disputes.
Well, I was struck by Jonathan's really long list of the matters that judges, orphans court judges in other states handle. And my question, I guess, is more to Judge Fisher and Judge Groves. Do you think that the Maryland's orphans court judge the parameters of the understood jurisdiction at the moment are sufficient? Should it be better defined? Should it be expanded, or are we okay where we are?
So I can jump in briefly. I mean, I think that both the attorney judges and the lay judges in Maryland have done a phenomenal job. If you look at the statistics provided, there's all these questions of transmittal of issues, and the information the Registrar McFarland provided showed that that would happened 18 times statewide in the last year. I don't see that as a giant problem. In addition, there was about 60 appeals statewide, so I also don't think that's a big problem. I think there's some overlap, like Kelly's talking about, with non-probate assets and occasionally a trust matter. Not as much in Baltimore County, maybe, Kelly, as in Montgomery County or somewhere else. But I see that there's some issues that arise that would benefit maybe from us having jurisdiction over related matters in order to prevent them having to go through circuit and district court. Judge Groves?
I would agree that the scope of our jurisdiction, I think, makes sense. It makes more sense than in other states where they issue marriage licenses and whatever else that they do. It doesn't jive with probate. But I would agree that expanding it to include trust would make a lot of sense for our court.
Okay, I see Byron, you have your hand raised.
To Senator West, to your point, I'm not going to comment on expanding the jurisdiction of the court. I will say, and this is something we'll cover at a future meeting, something that the registers have found is that despite, I think, the court's jurisdiction being relatively well defined, we do see the courts exceed the scope of their jurisdiction quite often, and that's a matter of concern. So, for example, we have orphans courts that order evictions. They don't have the authority to do that. That's a district court matter. We have just recently in one jurisdiction, a judge ordered a body to be cremated. That was an unlawful order. I mean, absolutely, unquestionably outside the scope of that court's jurisdiction. And I think that as part of the work of this task force, we are going to have to examine when the courts have overstepped.
Aaron,
Yes, I have a question for Mr. McFarland, if I may. Um, I'm just looking at your data, Byron, and thank you, Mr. Chairman, first of all. Um, did I read correctly that in your data that you proposed with Ms. Raleigh, I hope I'm pronouncing it right, that I just want to make sure I read it right, that for cases decided by lay people, that means not people like Judge Fisher and Judge Groves who are attorneys, but only 35% of those decisions are upheld. Did I read that right, or am I missing something?
Uh, yeah, you got that right, Delegate Kaufman. And well, I think I know appeals is later on the agenda, but yeah, the data that the research that I did back in 2022 as we were looking into reforming our orphans court in Howard County, there was an absolutely clear trend. I have no reason to believe that trend has changed. But the court, the systems that are least appealed and most upheld are the circuit courts sitting as the orphans courts. Then it is the attorney courts sitting in Prince George's, Baltimore County, and Baltimore City. But the most frequently appealed and most frequently overturned on appeal are the lay courts. So you read that correctly.
Thank you, Mr. Chair. Thank you, Mr. McFarland.
Judge Fisher?
Yeah, I just wanted to comment on some of those numbers because I think some of it's a little bit misleading. Those numbers are from 2019 to 2021. Those were COVID times. I don't know why we don't have any data from 22 to 25. I asked the staff at my registers to pull me some data about Baltimore County. For 2023, we had 3 orders appealed the entire year. All 3 were dismissed. For 2024, we had 3 orders that were appealed. Out of the orders that were appealed, 2 were affirmed and 1 was dismissed. In 2025, there are 9 orders. 2 were withdrawn, 1 was reversed, 2 were affirmed, 1 was affirmed from the appellate court, and we haven't received decisions in 3 of those. That's not a 50% attorney judges in Baltimore counties are being reversed. We have approximately close to 1,000 hearings that are held every year. For us to have 3 or 9 appeals, that's a pretty great rate, and I don't think that's reflective of the data that was provided. So that's all I have to say.
Thank you, Judge Fisher. Byron?
I have no idea how COVID times has any reflection on the rate of appeals. When we get down to appeals, I would be interested in hearing from both Kelly and possibly Judge McQueen. There are a million reasons why people do not appeal decisions of the orphans courts. Some people want their money as quickly as possible. Sometimes their attorney will counsel them that they don't have a chance. Sometimes it's just not worth the chance. And most of the orders and most of the hearings the court has, and we're about to get into this, are basically not controversial. So those numbers, I think, to say I have 1,000 hearings and only 3 are appealed is misleading, and we'll get into that in just a minute.
Okay. Judge Groves?
I would have to say, in speaking with some of the other judges in the state and getting their own data, that most of their appeals have been dismissed as well. So these numbers have to be taken in context. What were the matters that were appealed? What happened when they got to the higher court? And again, the majority of them have been dismissed or withdrawn by the parties voluntarily. So, and to piggyback off of Judge Fisher's comments, in Prince George's County, we have over 2,000 hearings. So to have less than 10 appeals, usually it's 3. This year it was 6 thus far, but it's pretty low. I think that in addition to looking at just numbers, we need to have some other data. What's the population of the jurisdiction? Again, how many cases are heard by that particular jurisdiction? What happened once it got to circuit court or to the appellate court of Maryland? And that information is not presented.
Thank you, Judge Groves. Kelly?
I just mentioned 2 things. It would be helpful to have some data on how many of the matters that are being looked at were actually contested matters. And I would also point out that this intermediate process of a de novo appeal creates extreme financial burden on the litigants because it's effectively a do-over, which you can then appeal to the Appellate Court of Maryland and then seek cert on after that. And so the fact that matters are dismissed is not surprising because of the financial burden associated with the appeal, and that appeals are often used as leverage. I know in the litigation context, if you know that you're about to go into an appeal where the whole matter is going to be tried again before the circuit court, you may just decide to resolve it simply because you need to cut your financial losses.
All right. Thank you. Was that it, Kelly? Okay. Joe, who's going to go through the slide deck information or the provided information?
Room number 3, Chair.
Yeah, we kind of like and just been kind of talking through it. So let's just officially go to 3, analyzing the efficiency of the procedures for adjudicating fiduciary contested and contested matters in orphans court and circuit courts.
Yes, Byron will. Are you able to share your screen?
Kelly, did you want to add anything right now? Or you want to wait till after Byron goes through the provided information?
John and I can wait.
Okay. Byron, do you have the ability to share your screen?
Yes, sir. Give me 1 second.
Okay.
Okay, can everyone see this?
Yes.
Okay, great. Okay, so in trying to, it was actually interesting as part of the legislative process, this analysis of contested versus uncontested matters was an amendment to the bill that I think actually is really useful in trying to get our heads wrapped around, what matters come through probate that are genuinely contested, that require, again, the name of this task force is to study fiduciary adjudication, not just sort of ordinary paperwork, but when we actually need to have a judge have a hearing and adjudicate a dispute, pleadings back and forth, evidence offered, not just sort of going through the motions. And as I said during last week's meeting, the legislature very intentionally many years ago, over 50 years ago, decided to move our probate system from a sort of judicial-oriented system to an administrative-oriented system. And so the overwhelming majority of probate is handled administratively by the registers of wills. But so what I want to go through is the data that we have accumulated, and this, just for background, this has come from our statewide database of all register of wills data, and we are the custodian of records. So if there is some record of something being filed, we have it. And so I'm going to start by breaking down, how many estates have any kind of activity any year, because I think that's really the best measure of how much activity is happening in probate. The number of estates that we open in a given year isn't exactly accurate because we have estates that reopen, we have estates that are open for several years. And so I'll start there, then we'll talk about basically how much of that is handled by the registers administratively, how much has to be acted on by the court, and then the kind of action that is required by the court, whether it is administrative, whether there was a controversial fee paid to the register, which means that there could be a controversy, but there wasn't actually in reality any controversy, there wasn't a dispute. And so it is more administrative than adjudicative in nature. And then lastly, the kinds of matters where there is actually a dispute. And so let me just define these for purposes of our discussion. So first, when I describe an estate that requires some kind of administrative action by a court, there is no dispute and there is no hearing required by law. So this would include things like signing off on administration accounts and estates, petitions for extension of time, motions for postponements, petitions for funeral expenses without any objections, those kinds of routine matters. The next would be court action required, but not a real dispute, but there's been a controversial fee paid. So this is when there needs to be some kind of court interaction, sometimes a hearing, but no one's actually disputing whatever relief someone is seeking. So this would include things like petitions for judicial probate to appoint a PR or special administrator when no one objects. We see an awful lot of this when there are foreclosure proceedings. So a bank, the largest creditor, will apply to be the PR. The family doesn't want to do it. The attorney for the creditor is the only person who shows up to the hearing. The hearing lasts all of 2 minutes. That's it. So yes, there was a hearing, or yes, there may have been a controversial fee paid, but there was not any real dispute. And then the last category is when there's real litigation. So this is when there's a petition or a motion and an objection, petitions to remove a personal representative, petitions to caveat, that's one of our big ones, disputes over estate expenses. We get people asking for hearings for just a status update on what's going on in the estate. So that's when we really need, when you've got two people or two parties or more genuinely at odds with each other, when we need to have a hearing, again, sometimes pleadings and sometimes evidence, and a court has to adjudicate that dispute. So when we get down and we look into this kind of activity, we find that we open about 30,000 new estates a year, and that number is actually relatively stable over time. The kinds of estates we're opening is changing, which is actually more of a financial matter than it is a sort of structural systemic matter. But we open about 30,000 estates a year, but we found that in this last fiscal year, in fiscal 2025, we had some kind of activity of some kind in about 104,000 estates. In about 75,000 of those, or about 72% of all of those estates, the only thing that needed to be done was some kind of administrative action by the register. These would be things like a request for copies, a letter changing someone's address, an amended Schedule B, which is part of the small estate process that typically doesn't go before the court. That is the overwhelming bulk of what we receive in probate. Alternatively, it was about 29,000 estates, or about 28% of all estate activity required some kind of action by a court. So something that the register could not handle on their own required the court to take some kind of action. And when we went down and we looked into that data, we were actually relatively easily able to segment out this first category, where it's a court requires some kind of, we need a court to do something, but it's purely administrative. And we were able to narrow this number down because these were cases where there were no objections or exceptions or hearings held. So it's simply, for example, someone files a first and final account and a petition for counsel fees, and there are no objections and there are no problems with anything that's been filed. That accounts for about 91% of the work of the orphans courts. The second category, as I said before, this is when someone's filed a controversial fee. There could be some kind of dispute, but ultimately no one objects. Again, a classic example would be someone files a petition to caveat, then withdraws it. So there's never actually any dispute heard by the court. Someone files a motion or some kind of objections that are withdrawn. Or I gave the example of judicial probate, where 9 times out of 10, someone petitions to be appointed. There's no objection. Only the petitioner shows up to the hearing, and that accounts for about 6.5% of the work of the court. And then the last bucket is when there is a genuine dispute. So this is a caveat of a will. This is a petition to remove a personal representative. This is a petition to allow a claim by a creditor when there's been a disallowance. And that accumulates to just about 2% of the work of the courts. So that was the research that we did. And the last note that I'll make is that in these second two categories, when a controversial fee had been paid, me and my staff went through each and every one of those estates, docket entry by docket entry. This is almost 2,500 estates to look at and see, was there a genuine dispute, or was it short-circuited because something was dismissed or someone withdrew an objection? And so again, this is the body of work that we're looking at for probate overall, both with the registers of wills and with the orphans courts. So as we think about the issues that Kelly has raised and the issues that we're here to try to make recommendations about, it's just, I think, important for us to understand, what is the nature of the work that we do within this system? And this is what our findings showed.
All right. Thank you, Byron. Is that it?
That's it. Thank you, sir.
Okay, Jonathan. Then after Jonathan, we got Delegate Kaufman, then Judge Fisher. Jonathan?
My apologies. I was forgot to unmute. Thank you, Mr. Chairman. Byron, I think definitionally in terms of what we're talking about here, the way we see adjudication is anything that goes before a judge. And so we would lump all of those, 29,000 odd cases in the label of adjudication. And I think we just need, as we're talking about this, there are different levels, obviously, because you're correct. I mean, and by the way, thank you very much for compiling this. It's a really outstanding batch of data. But I think we need to be looking at all of those 29,000 cases and how they are handled as we work through this.
If I'll just comment briefly, if I could, before Delegate Kaufman and Judge Fisher speak. John, I think, you are right in the sense of if we are looking at some kind of reform to the current system, you are absolutely right in terms of the total amount of work. So in Howard County, when we moved from an elected court to our circuit court, even though they don't have that many contested matters in front of the court, yeah, I mean, our judge has to sign, hundreds and hundreds of orders every year. So what you said, I don't think is unfair, and I appreciate your comment.
Thanks.
Delegate Kaufman? Delegate Kaufman, I think you're on mute.
I think it's important for the public that's watching and helpful to the public if Mr. McFarland would please define petition to caveat and what you mean by the controversial fee. Thanks.
Sure. Delegate Kaufman, so a caveat is the technical legal term for challenging the validity of a will or asking a court to construe a provision of a will. So if there's a question over how to interpret a will, or you want to argue that it is invalid, that is what a caveat is. And as far as a controversial fee, that's something that's paid to the register basically whenever someone interrupts the probate process. So when a personal representative is filing an account and someone has an objection to something that they're spending, for example, they would file a controversial fee. That matter would be referred to the orphans court. So it's really when there could be conflict, you have to pay that, but it's in, as you can see, it's not in most estates. Appreciate the question.
All right. Judge Fisher?
Yeah, I mean, I have a lot of comments, and I compiled a lot of data from my Register of Wills office, who was very forthcoming with things, and the data that they provided really doesn't line up. So I'm just going to give a couple examples. Register McFarland says that we had in Baltimore County 62 times when court action was involved, and 142 times that there was something prompted by the filing of a controversial fee. I had 677 controverted hearings scheduled last year. 493 were held. In addition, we had 1,371 delinquency hearings scheduled and 467 held. I don't think that data is reflective of what we do as a court. Today, I held a pretrial settlement conference on a caveat, a 3-day trial that was scheduled. I was able to resolve that, which our court is able to do. He probably wouldn't consider that controversial. It took several hours and it saved 3 days of judicial time. I think that's important. There's also motions that people don't respond to. They can be very complicated motions that we have to do legal research and make rulings on. And just because someone doesn't respond doesn't mean it's not a controversial action that requires court intervention. So the numbers don't align with any of the numbers I received from our registered staff. For example, in Baltimore County Register of Wills pulled me the numbers from 23, 24, and 25. These are for everything: order for funeral, orders to locate wills, court's approvals, notices of hearings. In 2023, we signed 9,087 different documents. In 2024, 9,115 documents. In 2025, we've so far signed 8,020 documents. I got into work today, there was 35 petitions of various kinds on my desk and motions for me to either decide to hold, to set in for a hearing, or to rule on, in addition to the other work that I had. I think that this data is not reflective of what it actually looks like in a court. Howard County has about 1,000 estates a year. Baltimore County has about 5,000. It's a completely different world, I understand, but the amount of work that we're doing and the nature of that work is so important. Even when I'm looking over an account, I determine whether or not there's something weird. Does it need a status conference? Do I want to make sure a property's not been sold if the estate's been going on for 2 years? That doesn't come through auditing. That comes from my close analysis of those accounts. I can reduce petitions for counsel fees if I think they're inappropriate without anyone contesting it. We do so many more quote unquote judicial things than any of this data reflects. And frankly, the data that came from multiple different sources in our office is not consistent with his data. And I'd like to once again point out that the data about the percentages of appeals was from 2019 to 2021. Where is the last 4 years of data? Why don't we have that if that's what we're talking about? You know, you're talking about Howard County changed during then. Why don't we have the data from what's happened with respect to appeals and transmission of issues for the last 4 years? I do have just a couple more things. I mean, we don't rotely just sign these documents. These aren't administrative. These are people's lives. These are people's estates. These are extremely important items to people that we take very good care of and spend a lot of time. We don't just sign our name willy-nilly to things, regardless if they're contested. We look at them and we determine if they're appropriate. We set status conferences all the times on things. The Register of Wills brought me over 2 original wills today that had interlineations or crossouts for determination as to whether I would accept the will as drafted with the interlineations, with changes to the wills. We make legal decisions that are not reflected in any of this data. And, you know, with respect to the de novo, I mean, if we have 3 total appeals in a year, de novo is not a huge problem. And I'd like to point out, if you have a protective order in the district court and you want it to be reviewed, you get a de novo hearing in the circuit court. It's not only the orphans court where this happens. I do agree that a de novo appeal might not be, you know, it can be a waste of time. It can be an ability for attorneys to do a do-over, but there is precedent for this in other courts as well. So I mean, I don't know where this data's come from. For my appeals, I have an annual report prepared by my judicial clerk in the Register of Wills that tells me the estate, tells me when it was transferred or when it was appealed, what happens with it, and then I can take a look. And I'm extremely proud to say I've been on the bench for almost 12 years and I have not been reversed once. And I think that all of the orphans courts statewide, whether they're attorneys or lay judges, take this job very seriously and try and do the right thing within the bounds of their legal knowledge and expertise. So, you know, I'm hoping that we can come up with some ideas about ways that we might make this court statewide better. I love the orphans court. I love this job. If I won the Mega Millions tomorrow, I would still be an orphans court judge. Besides my children, it is the most meaningful thing that I've ever done in my life is to be a judge of this court. So I want to make sure when we're looking at just rote numbers that we understand that we're dealing with people's lives and we're really trying to make a positive influence for those people. So it's not just numbers. We are available and accessible to the people. I'm sitting this week, I have 12 scheduled contested hearings. So this idea that I have 62 in my whole court for the whole year is crazy, considering the other things that I've also signed and reviewed today. So I just want to make sure, I think that John was probably closer off saying there's 27,000 things. You know, I think in Baltimore County, there was 4,589 things we looked at. Yes, and that's in the first category, but we look at all of those things. They're not just administrative things. They're not appropriate for a clerk in the Register of Wills office to just sign off on an account. The whole purpose is to have someone review what the auditors do to make sure that we're all doing it properly. So I'm very passionate about the Orphans Court, and I'm passionate about the work that we do. And I just want to make sure, especially for those who aren't as familiar with the courts themselves, that they understand what it is we're doing and what we're all putting into it. And, you know, I'm happy to provide any of this data. It was kind of provided to me Friday and today, and it's in a mixture of different formats. So I'm not able to provide Baltimore counties, but I can if it would be helpful to people to understand what they're actually really looking at. But, you know, if you really want to spend a day and find out what happens in the Orphans Court, come spend a day in the Orphans Court. You'll see and sign all sorts of different things. It's never dull there, I'll say that. So thank you.
Thank you so much,
So-
Judge Fisher. And I would ask that you provide that information to the rest of the team. Byron, if you can kind of lay out like what was the time frame that you pulled this data set from, but also why is there such a stark difference between what Judge Fisher is laying out and what you're laying out? I think we really need to do a cross analysis of both data sets to figure out where this major difference is. Before you answer that, I know we had 2 hands raised right after, so just be prepared for those questions and know that we only got 15 minutes left before the end of the meeting, and we still got to get through the appeals from the Orphans Court to Circuit Court. We may end up having to push it to the next meeting if we stay on this topic a little longer. So, but go ahead, Byron.
Yeah, I'll attempt, because we were absolutely not staying on 1, 2, or even 3 subjects right there. This was from fiscal 2025. That was the entire year. Part of the reason why, and this comes from our statewide database, this is not anecdotal. This is how many hearings we had this week, or this is how many times I had to pore over a statute. This is based on concrete data entered by the registers of wills based on the work done by the orphans courts. Why is there a big distinction and a big issue in Baltimore County? Part of that is that memos, for whatever reason, I don't know why they have this system, but an awful lot of internal work product in the orphans court is docketed in the register's system as orders when they're not orders. So there is a huge number of, it's the only jurisdiction in the state that does that. So if there's a big discrepancy, it's because of a process that is unique in Baltimore County. One of the things I want to say is that I don't know if the orphans court judges do this. They can answer this themselves if they'd like. Mary and I spoke with all 22 other registers about their perspectives on this. We made sure that we listened to everyone's perspective on how their courts work and the level of satisfaction with their courts. I can tell you without question, are there judges that come in and have a stack of orders and sign them without reading them? The answer is yes. And we've had judges like that in Howard County in the past. And there are judges around the state like that. So this concept, if Judge Fisher says that she meticulously scrutinizes everything that comes across her desk, I will take her at her word. But we are not talking about one judge in one jurisdiction. We are talking about 63 judges plus 3 circuit courts across the entire state. So when I provide this, I'm able to say with confidence that the data is accurate statewide data. If there is some kind of discrepancy in one jurisdiction, That's something for that judge. So I would just encourage Judge Fisher and your register to sit down and talk about why you have such a big discrepancy, because this is based on work product from you all. So, and I'd like to actually ask Mayor Judge or former Judge Register Raleigh to speak up, because I think she can shed some light on this as well. And I understand there were some other questions.
Yeah, I saw Delegate Kaufman. He put his hand down, so we'll go to Judge Raleigh, Register Wills.
I can't do both. Thank you. I'm listening to what Juliet Fisher is saying, and I also listened to Delegate Kaufman, because I think when he said to clarify some things between what is a caveat, and what I'm doing right now basically is saying doing both that I've done before. The Register Wills office does a lot of stuff every single day. My office, when an estate comes in, is opened up. It's not done by one individual. It's checked and rechecked, and then I check it. So when that information goes to those orphan court judges, that information has been checked over and over and over. When I was an orphans court judge, I looked at those files. I looked at every single one of them. What we did as because we were lay people on orphans court, we all opened it up at the same time. We looked at any discrepancies that we might see, but based on what I saw and what I do now is the Register of Wills are accessible to every single person that walks in that office every single day. And we're the ones right up front that are helping those people, and the majority of them never go in front of the court. So I take offense to the fact that we as the registers do our job, and we do it. And when it goes in front of those orphan court judges, it's done, and it's done correctly, at least in my office. And I know all the Register of Wills, and they do an excellent job. So that's what I have to say about that. Thank you.
All right, thank you. Judge Groves?
The numbers are not only incorrect for Baltimore County, but also for Prince George's County. I thought that the numbers that were presented were just for 1 month, because I asked my chief of staff to provide the numbers to me that she gets from our registrar's office. And for fiscal year 2023, each judge heard an average of 561 matters. We're projected for 2024 to hear 667 average each. So I don't know where those numbers came from, because it was not from our registrar's office, because again, our registrar's office provides numbers to us regularly.
Okay.
So that makes me think that the numbers may be off for the other jurisdictions as well.
Thank you, Judge Groves. Jonathan? Thank you. Back on mute, Jonathan.
Sorry about that. Thank you, Mr. Chairman. I would like to stipulate that from a practitioner's standpoint, both the judges and the registers do incredible work in our state, and and their work complements each other. And to Register Raleigh's point, I've seen accounts that have been gone over very thoroughly in the process come back from a judge with questions, and it's great to have that check on each process. But there's no dispute that both offices, both roles are being done really well and by really dedicated people. For the most part, I mean, I concede Byron's point that there probably are judges who just sign a bunch of stuff put in front of them, but I don't think that's the majority by any stretch of the imagination. And in my experience, all the judges work really hard within the confines, as Judge Fisher said, of their experience and training. So, I mean, I think for purposes of this discussion, if we look and say, all right, all of these things, these 29,000, or maybe the numbers are a little bit bigger than that, things that come up are what we're looking at, and how best can we design a system that serves the people of Maryland by providing an efficient way of getting those items that have to go before a judge at whatever level done well and accurately and fairly and in a equal manner. Yeah, that's what we should focus on. I don't think we need to get tied up too much in data specifics here.
Thank you, Jonathan. Judge Fisher?
Yeah, I just have one quick comment, and I would be remiss if I didn't say it. My register is the most wonderful register I think that's ever existed in the entire world, and her 41 members of her staff work so hard every day and do an amazing job. They are back and forth in my office when I'm there. I am back and forth in their office. We all appreciate each other. We work so well together. It's a well-oiled machine, and I am lucky to have every single one of them. So I don't want there to be any commentary. I am not disparaging the registers. I'm just making sure that it's clear to the members of the public and to the members of this task force what it is that we do, because most of you haven't had the experience of being in an orphans court, and I want to make sure that you understand what it really looks like above and beyond any numbers you might receive. That's all. Thank you.
Thank you so much, Judge Fisher. Is there anybody else that want to add any last commentary before we head off to the appeals from the orphans court to the circuit court? Because we have 8 minutes left in the meeting, and so I just want to make sure. But if there are none, I'm going to ask that Joe work to explain Maryland's judiciary's data, and then Byron, we're going to ask that you discuss the Register of Wills data.
Thank you, Mr. Chair. And this is data for fiscal year 2025. I just want to say Holly and I are happy to get any data that the task force desires. Please let us know what kind of data you want, what the time period is, including the orphan court judges. We're happy to receive your data and do what we're here to serve you. This is data from the Maryland Judiciary. Appeals from the orphans courts filed in the circuit court, doesn't include the appellate court, and just a total of 60. And this is a breakdown by jurisdiction. I have asked for numbers, and then okay, so those are just the appeals. We've asked for further distinction between de novo appeals and transmission of facts. That is going to be done manually, so that's going to take a little bit more time. The other data, and I'll make this smaller, is just the number of guardianship of minor cases that the circuit courts handled in fiscal year 2025. And the total here, as you can see, is 1,346. It's broken down by person and property, and just property. So most of them, 1,000, are guardian of the person. So those are the guardianships. Now the orphans court also handles guardianship of the minor. So that just get for some context. I've also asked the judiciary for numbers about the number of cases regarding trusts. So to get a sense of what the universe is for the number of cases they typically handle. I've just asked for fiscal year 2025. But if the members want go back 5 years, we can do that. And that's all I have right now.
Thank you, Joe.
Do you have any questions?
All right, no questions. Byron, do you want to share your screen and go through the Register of Will data?
Okay, thank you, Mr. Chairman. So I appreciate the data that was provided by the judiciary, which came very close to being, it was almost identical to what we came up with as the registers. So the judiciary said that they had 60 appeals and we had 64. Everyone is welcome to look at this document. I, again, with my wonderful staff who are just really good at pulling these numbers and quickly analyzing it, were able to figure out why they were slightly different for some jurisdictions, but not all. The jurisdictions that are highlighted in green, our numbers matched up identically. For some of the others, they were a little off for three reasons. One is that we were also counting appeals to the appellate court. For people who are watching, if you have a final judgment of an orphans court in Howard, Harford, or Montgomery County, where the circuit court sits as the orphans court, you don't have the option to appeal to the circuit court. You have to appeal directly to the appellate court, okay? In the other 21 jurisdictions, you have the option of appealing either to the appellate court or to the circuit court. So we did try to capture all appeals, not just appeals to the circuit court. And there were some cases where we were looking at when, if you look at Allegheny County, just as an example, our data showed that they had one appeal. The judiciary said two. The reason for that was that by the time that second appeal had been opened by the circuit court, it was after a new fiscal year began. So the registers have some amount of time under law to transmit the appeal to, we have 60 days to give the appeal over to the circuit court. And it's a different procedure with the appellate court, but we have that period of time. So because there is that delay, if you are filing something at the end of a fiscal year, sometimes the clerk's office will not actually open that new case until the following fiscal year. So there were cases that we didn't include because we got the notice of appeal in fiscal 24 that the judiciary included because the case was open in fiscal 25. And sort of the opposite, there were some cases where we got the notice of appeal in fiscal 25, but they did not open the case until fiscal 26, our current fiscal year. So that was the reason for those numbers being slightly different. And we also did include the total number of transmittals of issues, which you can see in the right-hand column, which was a total of 18 for the state.
All right.
And that's all I have.
Are there any questions, Judge Fisher?
Yeah, I just wanted to know if there was data about how many of these appeals actually led to a reversal of the prior opinion. And then I guess the second question of that is, and what's the percentage of circuit court cases that are reversed on appeal? Joe, that might part be for you.
Could you repeat that question?
So for Mr. McFarland, did you
Oh.
look into the data first to see how many of these cases on appeal were actually reversed in 2025 or even 2024? Because 2025 might not all be resolved. And then Joe, I was just asking if you could find out the percentage of circuit court cases that are reversed on appeal.
Oh, by the appellate court?
Yes.
Yes, ma'am, I can do that. What years do you have?
Maybe just 2024. I would imagine they're mostly resolved by then, or maybe 23 and 24.
Okay. Will do.
Yeah, I'll just say that the reason that, I mean, probably very few of these cases have been resolved. Or if they have, it's because they've been voluntarily dismissed. It's not necessarily that the orphans court got it right or wrong. This gets back to what Kelly said earlier, which is that there are a million reasons why people may file an appeal for litigation purposes as leverage, or they might decide that they are just going to accept what a decision they may not agree with, just so they can end the estate. And the reason, I mean, we don't track this data. I mean, we have the raw numbers, but in terms of the outcome, the reason that we have data from fiscal 19, 20, and 21 is that it takes a long time for these things to be resolved, especially if it goes to the appellate court. More recently, even if we look back to fiscal 24, a lot of those cases aren't going to have reached conclusion yet. So, I guess I would ask the question, is there any reason why anyone could reasonably articulate why the rate of reversal or upholding based on the type of court from 19 to 21 and today would be any different.
I guess that's because I have the data from 22, 23, and 20, no, 23, 24, and 25. All of the cases from 2024, the appeals from the Baltimore County Orphans Court, we already know what's happened with them. And we know 6 of 9 for 2025. So I was assuming that since my judicial clerk in the registrar's office had that information, I'm assuming that when it comes back from the circuit court or the appellate court, that your staff or the staff of the registrar's offices would be notified. So maybe if you could try and provide the 23 and 24, what happened with those appeals, that would be helpful.
We have the issue is that this has just been given to us, and unfortunately, I'm not sure why, but the registers got these requests from judges in a completely scattershot way. Some got them from their own judges, some did not get this request at all. So I have no idea what your rhyme or reason was to try to accumulate that information. I got a request from a judge in a totally different jurisdiction who I don't work for, so I'm not sure what that was about.
Well, we
we
actually
can
get them
try.
every year. This is like, I can't share my screen, but this is what I get every year from, oh, you can't see, from our register. I just pulled them out of I have a drawer where I keep them. 2023 petition docket summary about what the number of hearings are, the cases that are transmitted, what happens on the appeal. So I was just assuming that maybe all registers maintained a similar data set.
I mean, again, that sounds like a unique procedure that you have in Baltimore County, so.
Okay, so could you take a look and see if perhaps you could look into some of the 23 and 24 data? Because I think it would be helpful for both the public and the people on this task force to determine.
I will continue to say that I do not believe that the rate of appeal, based especially on what Kelly said, is a great measure of satisfaction with the court system as it stands.
Okay, just whatever data we can get, I think might just be helpful. I think it's helpful to know, if we're talking about that lay judges are reversed 70% of the time or 65% of the time, but we don't have any data from the last couple of years as to whether or not that's a continuing trend, or since there's been increased judicial education, maybe that's changed. I don't know.
Okay, Mary. You're on mute.
Sorry, thank you, Chair. I think when I look at least in Frederick County, I've looked at the number of appeals, and I think part of it is that I don't know how many people that, unless they have an attorney, actually know they have the right to appeal. So that we have no idea of how to get those numbers. The second thing is that because our judges don't do their own orders, we have the chief register, chief deputy who does the orders for them. So I think based on that, we probably see probably don't see as many appeals as if those judges had to do the orders themselves, because they're not trained. They don't know how to do an order. So I think when we look at the appeal process, we have to look at many different variables here, and within each jurisdiction, why there might be a difference, or why the appeals might seem like, well, we didn't have many. Well, there might be reasons for that. Thank you.
Okay. Thank you so much, Mary, and to everybody else on the team. Thank you guys for providing information. This has been a lot of great data sets, and Judge Fisher, if you can provide the information that we discussed earlier.
I just have to confirm with my register. She wasn't in the office today, and some of it was the yearly documentation I get from her staff and my colleagues get. But then I did ask them to pull the number of documents that we signed. So I just want to confirm with her that she's okay with me sharing it, but I'll get in touch with her tomorrow and make sure that's okay.
And Judge Groves, if you can do the same thing as well. I think from both jurisdictions, if there is a difference between the data sets, at least having what each jurisdiction between Baltimore County and Prince George's, what you guys have, and that way we can kind of, tap this the appropriate way.
Yes, and the reason that the judges across the state were trying to get the information was just to verify the numbers that are being reflected, to verify that they're accurate. So hopefully we can get some numbers from other jurisdictions too.
Okay, thank you. All right, Mary, did you have your hand up, or this is just a continuation? All right. So listen, we're gonna close out the meeting. I just want to let you know that we will be meeting again next Monday, November 10th at 6 o'clock. We were able to get through all of our items on the agenda for today. Next week, we'll be examining the qualification, selection, and training of judges, hearing probate and other fiduciary matters in Maryland and orphans court jurisdictions, and the 3 jurisdictions that requires orphan court judges to be attorneys, and in the 3 jurisdictions where the circuit court judges sit as orphan court judges. And we will be analyzing the effect of the different qualifications of orphans court judges and related litigation procedures on the uniform application of justice in Maryland. So these topics, they all be discussed next week, November 10th, and discussions will continue at the following 2 meetings on November 17th and the 24th of the task force. So we got a lot of information to get through. You'll probably be receiving some of this information so you can read ahead prior to the meeting with anything that was provided to the group, and then we'll get everything posted online as well. But the time is now 7:07. We were supposed to end at 7 o'clock. We probably should have set these to go for about an hour and 30 minutes so we can really tap in, because it's a lot of information and we don't want to rush through this. This is a very important issues and topics, and we don't want to shortchange the people of Maryland that they miss out and we don't do our due diligence. And I believe this is the great group, and we're going to get everything done that we said we were going to do, and we're going to get it done right. So thank you to everybody that's participating. Thank you for everyone who's been joining us and watching online, and looking forward to when we do the open meeting for the community to come in and hear what everyone else has to say about these issues as well. So I'm going to adjourn the meeting at this time, 7:08, and look forward to seeing everybody next Monday. So thank you guys and take care.